Number 205, the people of the state of New York versus Prince Clark. Good afternoon, counsel.
Good afternoon, Your Honors. My name is Denise Powell, and I'm here representing Prince Clark on this appeal. This is a case in which the 21-year-old...
Would you like some rebuttal time?
Yes, I would. 2 minutes, thank you, Your Honor. This is
How many minutes?
2?
2, yes.
This is a case in which the 21-year-old Prince Clark, who's charged with murder, disagreed with his attorney about the theory of defense that should go to the jury. Instead of pursuing the defense that his professional knowledge, skill, and judgment informed counsel should be advanced, defense counsel deferred to this defendant.
Counsel, what isn't a justification defense an argument or an admission to the public, to that jury, in that court, yes, I killed this person. But I shouldn't be held accountable for it in the sense I shouldn't have criminal liability for it. But yes, I killed this person. Isn't that the equivalent of that choice about whether or not to plead guilty or not guilty that I know you concede is strictly
fundamental,
strictly
absolutely,
within the control of the defendant? Why is it not the same thing?
It's not the same thing, Your Honor. A justification defense is an ordinary defense. Mm-hmm. It actually puts the people, it places the burden on the people to prove beyond a reasonable doubt that the defendant did not act in self-defense.
Would the justification defense have applied to the assault charge, counsel?
As to the first victim, or Tali Moran?
Right.
No.
So the defendant said, it's not me, this is a misidentification. I basically want to roll the dice on getting acquitted for everything, not just the murder, but for the assault too. And if the justification defense wouldn't apply to the assault, doesn't his, decision to stick with the misidentification make some sense?
It may very well make some sense, Your Honor, but the question here fundamentally is, who makes that decision? Is it the decision of defense counsel, or is it the decision for the defendant himself? So it really turns on whether or not this decision as to the theory of defense that goes to the jury is in fact a fundamental one, or is it one of a matter of strategy or tactics? So I think we have to look at...
Or is it something in between?
Well, at this point, I think we start with Jones v. Barnes, and where the Supreme Court actually was faced with this very question: where do we divide the decision-making power between the defendant and defense counsel? And the court said, the court acknowledged that in an adversarial criminal justice system, that in fact, the attorney has the superior ability to make certain decisions to protect a defendant's rights to a fair trial and to just overall fairness. And the court basically, in sum and substance, held that what's mandated by the Constitution is a lawyer-centered model of representation.
But if
within that model,
excuse me, counsel, if the lawyer here had decided to go against his client's wishes, and at some point, either at the beginning, before the court instructed the jury and asked for the justification defense, let the judge instruct the jury on that, or at the point where the jury sent out a note asking about self-defense and justification, given that defense, or given that instruction, and then the defendant had gotten convicted of either of these charges, wouldn't we still be here? Wouldn't he be complaining that the lawyer actually went against his wishes and decided on a defense that he didn't want?
He may very well be complaining about that. However, he would be wrong. The question, again, is whether or not a counsel, to be effective, can defer a non-fundamental, strategic, tactical decision to his client. That's
okay,
the
Ms.
bottom
Powell,
line.
so how, as a practical matter, would they assert the defense of raise the defense of justification?
In this case?
Yes, in this case.
It was quite, it would have been quite easy. In fact, in the absence of defense counsel's advocacy, without any mention of self-defense in his opening, which he didn't even make, or in his closing statements, the jury saw it itself, and from the people's own evidence. The people put in a videotape, a surveillance tape, that basically laid out what occurred, showed in clear terms what occurred leading up to the fatal shooting. And based on that tape, and also obviously the incident that led up to it, there were two witnesses that discussed the various acts that led up to the fatal shooting, the jury saw, without even an instruction, that this case involved justification. So yes, counsel could have very easily, even though, if the defendant, decided that he wanted to exercise his right not to testify, the justification defense would have been charged. And in fact, the appellate division, both the majority and the dissent, had no problem finding that, when you look at the evidence in a light most favorable to the defense,
familiar
the
with-
justification was what should have been charged.
Are you familiar with
Could have been charged.
our decision in Enriquez and also Rossborough, where we talked about a defendant's right to waive the right to effective assistance of counsel?
I'm aware of Henriquez, and that case is completely distinguishable. In Enriquez, and as opposed to here, Mr. Enriquez basically instructed his lawyer to do nothing. And then when the court went through basically the Ferretta warnings, he was non-responsive.
Well,
So
here,
in that
here in,
scenario,
in a sense, that's what the defendant did. He instructed his attorney to do nothing with respect to a justification defense that the attorney thought was possibly a good defense. So, and there was a very thorough colloquy here. I mean, so.
Very thorough what?
A very thorough colloquy. So instead of creating this situation where the attorney is damned if he doesn't, damned if he doesn't, should we, under Enriquez, why shouldn't we say that he knowingly, voluntarily, and intelligently waived his right to have his attorney make that determination?
Your Honor, the question here is, Enriquez is complete instruction to do nothing. Here, basically, the defendant wants.
We disagree that there's a distinction there. Then,
Here, the
did he do
defendant
that?
is.
Did he waive it?
No, the defendant is basically directing his attorney to press his pro se defense, and this court has.
No, he wasn't asking him to. He could have pressed that defense anyway. He was asking him to refrain from pressing another defense. That's the part of this that we're talking
He's asking. Mr. Clark was insisting, and in fact, in the end, was successful in compelling this attorney to press a ludicrous mis-ID defense and not press the defense that was that
I
this
don't know.
evidence
I
was.
saw that videotape. I don't think that was.
I was going to say that, too. I watched the videotape, and to be honest, this was a very intelligent defendant. I think it appeared in looking at the whole record like he was able to weigh quite effectively for a non-lawyer, I thought, the difference between justification, which involves in some level admitting before the jury, even if he doesn't testify, you're correct, you're still admitting that the crime took place and you did it, and the misidentification. Particularly, I was struck in the tape by two things. First, it was difficult, I thought, to clearly see a person's face in the videotape, particularly at the shooting in the hallway. And so I thought, well, that's at least a rational decision for somebody to say. And the other thing is that justification seemed to be so hard to argue in a shooting where you've got that test where you've got a two-part test, subjective and objective, and here it looked like the victim was on the ground and the person doing the shooting shot him a number of times. So in other words, it wasn't a one-shot reaction to it. So for those two reasons, it seemed to be a very rational decision. So that doesn't address your point, which is that it wasn't his call to make. It was somebody else's call to make.
I think that's the fundamental thing that this court
Yeah.
has to reach.
But you see what I'm saying?
Well, I would disagree.
Okay.
It's not just the tape that's involved. I mean, for the mis-ID defense to be successful, the jury would have to basically ignore the fact that this defendant's friend of many years identified him as the man on the tape. But the tape itself shows quite clearly that Mr. Clark is attempting to retreat into his own home. He is not waving or brandishing the gun. And these two fellows, Mr. Wisdom and the unidentified other, actually pursued my client into his own home. And it's at that point, once they actually entered the lobby, that they attacked him. And at that point, they slammed him against the wall and attempted, the jury could infer, to take the gun away. And if that's not self-defense.
Thank you, Ms. Powell. Counsel?
Good afternoon. My name is Shalom Tversky, and I represent the respondent. Your Honors, you don't have to decide whose call it is, because based on the state of the law at the time, counsel, even if he did defer, and even if he thought it was the defendant's call, not his, that was reasonable, because this is simply an ineffective assistance of counsel case. This is not Colville, which was a trial court error. This is simply, was it reasonable for the defense counsel to, if we assume, and we don't concede that, but if we assume that he simply deferred, was that reasonable? Almost exactly 1 month before defendant's trial, the appellate division decided Colville and said, we can't decide with the submission of lesser included offenses, whether it's fundamental and therefore defendant's call, or whether it's tactical and defense counsel's call. Then 1 month later, defendant's trial. Defense counsel makes his decision and allegedly defers to defendant's decision to go mis-ID rather than justification. 2 years later, this court decides Colville, reverses the appellate division decision, and in that decision says, we've now resolved the uncertainty in the law.
But doesn't your argument assume that there was a strategy here? I mean, it seems to me that the record is pretty clear that counsel did not think that he had any discretion whatsoever in how to try this case.
I would disagree with that, Your Honor. If you look at it,
well,
counsel...
if he did, why would he bring it up? Why would he bring it up in the first place?
Your Honor, what he brought up, if you look at A341 in the record, what counsel brings up is, prior to that, he knew this is a very weak case for him. He knew he couldn't get a complete acquittal, whether it was justification or mis-ID, because of the nature of this evidence. So he kept trying to get him to plead guilty. When the defendant kept saying, I didn't do it, I don't want to plead guilty, then what did he do? He said, go EED. At least you'll only get a manslaughter on the counts regarding wisdom. And what does defendant say? This is defense counsel's recounting their conversation to the court. I said go EED, and he said, I don't want EED, I don't want justification, I don't want you suggesting anything that it's me on that video surveillance video, on that surveillance tape.
Did he understand the possible result, what possible verdict there might be if indeed he was successful on justification? Did he understand that?
Your Honor,
what does the record show?
The record shows that he kept saying, I'm completely innocent.
Right, isn't he trying to get off? Do you think he understood what, if he was successful on justification, what the result might be?
This seemed like a very sophisticated defendant, because the fact is
well, his
that,
lawyer didn't get it, so I'm not so sure.
Well, I'm not so sure about that either, Your Honor, because what I mean is that the defense counsel, it's not so clear that defense counsel didn't realize, you know what, between these two weak defenses, I better go with mis-ID and not justification. Okay. Because you never hear out of the defense counsel's mouth why he thinks
a different question. Does the record show that this defendant understood the possible result of being successful on a justification defense? You might think the record doesn't show that. I'm just asking.
The defense, what the record shows is that defendant was adamant, and as the appellate division said, that he wanted to announce to the world that he was completely innocent. That would have applied...
Well, you want to get off the charges.
Exactly. And that would have applied to Talleyrand as well. But a reasonable defense counsel would have realized that justification wouldn't have gotten anything but an acquittal, if it could work, on the murder counts, but not on Talleyrand's counts, and also nothing regarding the weapons possession count where justification wouldn't apply. So the fact is that what
But is
this...
there anything in the record to suggest the defendant understood that and weighed that that was in the balance?
There's nothing specific in the record that shows that, other than him remaining adamant that he didn't want his attorney...
Does that mean that maybe he has a 440 on that, whether or not he really understood this choice?
Your Honor, if this court wouldn't find that there's enough objectively to see that the defense attorney reasonably opted, because he doesn't express his subjective reasons as to exactly what he thought about justification, this court should apply an objective standard, and to say that based on some of the comments that were made by this court, why justification was not as good as mis-ID. When you have a grainy video, when you have, the appellate division says the images are indistinct, and where the defense counsel quite effectively argued in summation that Mitlin, who is the only person who identifies defendant as being on that surveillance tape, might very well have been coached. However, if this court would find that there isn't sufficient evidence in this record, then yes, a 440 might be an appropriate way to sort of flesh out exactly what all the specifics of defense counsel's rationale was. But the fact is that there is no reasonable probability that even if a justification charge had been given in this case, that first of all, there's no reasonable view of the evidence so that it should have even been charged. And even if you want to say it should have been charged, there's nothing to say that the jury would have bought it. Defendant was the initial aggressor regarding the deadly physical force. There's no way around it. As the appellate division said...
Hadn't he retreated from the initial encounter, though? And then he was going back into his apartment, and the victim came after him?
After he had first retreated to his apartment, after he had been simply beaten up, he then comes out again. Mitlin says, shaking with anger.
They have another interaction, but then he goes back. He walks away, and he's chased, and he's attacked.
Your Honor, deadly physical force cannot be used in the face of regular physical force. All you have is wisdom.
Unless he thought that he was going to grab the gun from him and use it to shoot him.
Your Honor, you have wisdom rushing him. You have nothing in wisdom's hand, nothing to say wisdom is armed.
My point only is there not some reasonable view of the evidence that could have led a jury?
Even if there is a reasonable view of the evidence, even once they're struggling against the wall, we're talking about a matter of 10 seconds where defendant then shoots wisdom, the unarmed wisdom, 6 times. So there's no reasonable probability that even if the jury had been instructed on justification, that they would have acquitted the defendant of the counts related to wisdom. So under those circumstances, the people would argue that defendant has failed to show that counsel was ineffective in this case, and the conviction should be affirmed.
Thank you, counsel. Ms. Powell?
Just a few things, Your Honor. Yes, the colloquy between the court and Mr. Prince, when he talked about the remedy that would follow from a successful justification charge, was completely misleading. The court, he basically talked about EED with justification and suggested to this client, my client, that if he were in fact successful with the justification defense, that it would end up in a manslaughter conviction. That's number one. And number two, my adversary talks about the appellate division decision in Colville, and that somehow, counsel might have been confused by that and should have followed that. The fact of the matter is that in Colville, the decision specifically says that that the defense counsel acquiesced to the defendant's decision. So the Colville appellate division decision should not have been controlling in any way with respect to my counsel. With respect to whether or not the justification defense would have worked, my adversary talks about being shot 6 times. Yes, he was, but you have to look at the circumstances under which those 6 shots were fired. It was a tussle, a struggle, and in fact, the Wisdom's accomplice joined in and began to kick him. So how the gun went off, we don't know. It may very well have been triggered as a result.
You don't have much time left. Can you quickly turn to the jury charge issue?
With respect to the jury charge issue, the court has an obligation under 300.10 and 310 under the statute to meaningfully respond to a juror's proper request. In this case, the jury specifically asked for, in essence, a justification charge. At that point, the court had no discretion as to whether or not to give an answer to that charge. Instead, what the court did was basically charge justification out of the case. And he specifically told this jury that you are to decide whether or not Mr. Clark intended to kill, and justification simply is not your concern. In fact,
Doesn't it have to be preserved?
Well, Judge, I think that under this court's jurisprudence, I think it's Gonzalez, the court said that's actually
Well,
structural.
most recently, though, we had People v. Mack.
I'm sorry?
People v. Mack is most recent, and it makes the argument, I think it makes it more difficult for you that I think you have to preserve under Mack, this prong of the jury note.
I'm sorry, I'm not that familiar with Mack. Is Mack an Orama case?
Yeah, it's relatively recent.
That's what I thought.
Yeah.
But this is not, and I think that the court in Gonzalez announced the rule that, under 310.30, the court must give a meaningful response to a proper jury question, and
But
given...
isn't it analogous to Orama in that, in Orama, the statute likewise says what the court must do? But we have found that that has to be preserved and raised as long as counsel knows what the jury has requested. So
Right.
why would that not apply?
And also, I should note that defense counsel objected to, in the end, the court's informing this jury that justification was not their concern. And to that extent, it is preserved.
Thank you, Ms. Pell.